Further, as a result of pleading guilty, the effect of the guilty plea is that you'll be found guilty by the court.
Yes.
And then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 3rd degree. This offense is punishable by a term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, or 30. So at the time of sentencing, so I'll select one of those numbers, 9, 12, 18, 24, 30, or 36, and that would be the number of months in prison you'd have to serve for the tampering with evidence charge. You understand that?
Yes, Your Honor.
Now, the charge also has what we call a firearm specification that's attached to it. This firearm specification requires the court impose a mandatory prison term of 1 year that has to be served prior to and consecutive to whatever prison sentence I impose on the tampering with evidence, the 9, 12, 18, 24, 30, or 36 months.
Yes, Your Honor.
So you serve the 1 year first, and then you would serve whatever the prison term is on the tampering with evidence. So they have to be served consecutively, which means one after the other. You understand that?
Yes.
I do not have the ability, if you've heard the term concurrent before, concurrent means sentences are run together at the same time. I'm not allowed, I don't have the authority to run the firearm specification, the prison term for the tampering charge concurrent. They have to be consecutive. Do you understand that? Any questions about that?
No.
Okay. And in as much as the firearm specification requires a mandatory prison sentence, that means I'm required to impose a prison sentence on the tampering with evidence charge as well, the 9 to 36 month range I mentioned. You understand that?
I do.
Now, are you currently on probation or parole to any other courts or agencies?
I am not, Your Honor.
Do you have any other criminal charges pending against you anywhere?
I do not.
Your Honor, I don't think she does. She does have quite a checkered criminal history and does have some substance abuse issues, and she doesn't believe she does. We don't know of it. We don't.
Fair enough.
I just want to.
I'll explain the reason I'm asking. It's nothing more than if you have a pending charge against you, felony charge, and you're sentenced to prison on that other case before you're sentenced on this case, I could run. I'd have to run consecutive. This firearm specification has to be consecutive to anything else.
Okay.
But that's only if you're sentenced to prison before you come back here for sentencing.
Yeah.
Doubt that's happening because you're not going to get out here. It doesn't appear to that's the case to go anywhere else.
Yeah, Your Honor. I don't believe.
Okay, well, that's the only reason I'm telling you that. If you're sentenced to prison before you're sentenced here, I could run my prison term consecutive to that.
Okay.
That's the only reason I'm asking that. I can't run it, concurrent or consecutive to some possible future unknown sentence. It's already got to be imposed.
Yeah, I honestly, Your Honor, as far as I know, I don't have anything.
Fine. That's the reason I was asking. The only reason I was asking.
I've done everything in my possible ability when I fall down and if I fall down to get myself back into either a psych ward or any type of treatment. I never thought I'd be back in front of a judge again, Your Honor. So.
Were you? I may have asked you this, and if I did, I'll ask it again because I can't remember if I asked. Were you on probation or parole or post-release control to any other courts or agencies when this happened?
No.
Now, if a prison term is imposed in this case, upon your release from prison, you could be placed on what is called post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you completed the prison sentence, and it could be, in this case, up to 2 years. You understand that?
Yes, Your Honor.
And if you're on post-release control and you were violating any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. You understand that?
Yes, Your Honor.
Now, aside from the possible prison or the mandatory prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case up to $10,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I was explaining the prison sentence, prison sentences, the possible prison sentences, and I told you it was mandatory, though, that prison had to be imposed. That means you are not eligible for probation, what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Now, while you're not eligible for community control sanctions here at the time of sentencing, after you have served any mandatory prison term that would be imposed in this case it would be the 1 year for the firearm specification, you would be eligible at some point to request judicial release, which is a motion you could file with the court requesting to be released and put on community control sanctions. Now, you're not entitled to it, and it's not guaranteed you would get it, but you could request it after you serve some period of time after the mandatory prison sentence. You understand that?
Okay, thank you.
Lastly, when we come back here for sentencing, you'll have the right at that time to say anything you want me to know or consider.
Sure.
Your lawyer could speak on your behalf, recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor, thank
Do you
you.
understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
I do not,
You
Your
understand
Honor.
all the possible consequences?
I do.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have her review the reports with you, discuss issues, answer whatever questions you may have?
I have.
Are you satisfied with the advice and counsel of your lawyer?
I am. Yes.
Has she or has anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, any questions for me then at this time regarding anything we've talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions?
I do not, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show if we had a trial. I want you to listen to what she says, because then I'm going to have some follow-up questions for you, all right?
Yes, Your Honor.
All right. Ms. Himmeline?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on September 15th, 2025, there was a shooting that took place at Fox Run Apartments in the city of Willoughby, Lake County, Ohio, where DeMonte Perry was shot and later died. The defendant was interviewed by the Willoughby Police Department, where she admitted that she was aware of the shooting that occurred at Fox Run on September 15th, 2025, and that her son, Christopher Ferrona, had called her sometime after it happened. Christopher Ferrona told her that he was in trouble, and she told him that she was coming down there. Christopher Ferrona told the defendant that he had the gun. The defendant admitted to the Willoughby Police Department that she retrieved the gun from the bushes at Fox Run Apartments, again located in Willoughby, Lake County, Ohio, in order to assist Christopher Ferrona. She took the firearm and gave it to a drug dealer in Cleveland. The Willoughby Police Department was able to recover the firearm from that person, and were able to confirm that the same firearm was used in the shooting on September 15th, 2025. Thank you.
Thank you. Ms. Ferrona, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, I have.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Okay, Your Honor, to a degree. When my son called me, I didn't go into where he was. We called Melvin Harris. I did go as close as I could. I did not go in. My son told me the gun
You did not go in where?
To the apartment.
to the apartment where it had happened. The next day, my child had my food card. This can all be proven.
I want to know if you tampered with this gun, which was evidence in a proceeding.
He wants to know, did you go and retrieve the gun
I
from
did,
the
Your Honor.
bushes?
Afterwards, yes.
Knowing that it was potentially evidence in a criminal
I did.
investigation?
Yes, Your Honor.
And you possessed it when you got it?
Yes, I did.
Anything else you'll be able to explain to the probation department. I just
Okay.
want to find out whether you are admitting to the specific elements of the offense that you...
Okay, I didn't know if you wanted to know exactly what had happened.
You're going to get a chance, you're going to go to the probation department and meet with them and give them your own version twice of what happened. You can talk to them orally and have an oral interview with them, and you're also going to get a chance to write it out if you want.
Okay.
So you'll get that opportunity. I'll get a chance to look at it. So I'm not review that.
Thank you.
Not an opportunity. I will review it. So, but the point here is just that you're admitting to the specific elements of the charge,
Okay.
which is what you just said, that you went, got that gun,
Yeah.
knowing that it was evidence in a criminal proceeding.
Yeah, I'm sorry, I was just a little confused.
That's all right.
Thank you.
Did you know that he had died at that point then?
I did not.
Right,
It
well,
doesn't, I don't think it changes
No, it doesn't
the
change.
actual elements of the facts.
Yeah,
but I
Because it's just
totally-
that it's a criminal investigation
Yes.
that you knew was going
Correct.
on. You knew that, correct?
Yes,
Yeah, okay.
yes.
Very well then, regarding count 1, charging you with tampering with evidence of felony of the 3rd degree, what is your plea to that?
Guilty,
Regarding the one-year firearm specification, what is your plea to that?
guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand that document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer, is that correct?
Yes, Your Honor.
Ms. Corrigan, is that accurate? Did you review that with
I did,
Ms.
Judge.
Rona?
Yes.
Read it over with her?
Yes, sir.
Did she indicate an understanding of it to you when you did that?
She did, very much so.
Is that correct, Ms. Rona? So you understand the document?
Yes, Your Honor.
Any questions for me about what it says?
No, Your Honor.
It also appears you signed the document. Did you in fact sign it?
Yes,
You witnessed that, Ms. Corrigan?
I did.
And Ms. Himmeline, you as well?
Yes, Your Honor.
Very well, that at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, tampering with evidence, a felony of the 3rd degree in violation of 2921.12A1, along with the firearm specification. Count 2 will be dismissed. I'm going to defer sentencing, order a pre-sentence report and investigation, and I'll continue defendant's bond. Is there anything else for the record at this time, Ms. Himmeline?
Your Honor, we did a victim impact statement as well.
Victim impact statement. Ms. Corrigan, anything else?
No, thank you, Judge.
Thank you.
All rise.
All right, I'll be in to see you. Depending on the weather, it might not be tomorrow, but.